I come to the non-lawyers to hear their views. Yeah.
Quickly, I think that this whole debate about regional tribunals is born out of a certain mischievous attempt to invoke a certain emotive reaction towards the introduction of the policy. First and foremost, we have to understand that the setting up of regional tribunals is not introduction of any new court system, because as my learned seniors in the studio have already said, if you look at Article 126 of the Constitution, it already establishes the judiciary. And in fact, we must state that regional tribunals and the high courts are put on the same pedestal. True. If you look at if you want to argue that it's in a hierarchy, you see it says that the high court and regional tribunals.
Yeah, the judges have the same qualifications.
Yes. Now, when you look at it, then you come to Article 142, which my learned seniors have talked about. I respectfully would want to depart from the interpretation that they have put on Article 142, because I understand it to mean that it is mandatory for every region to have at least one regional tribunal. But as to whether I should have more regional tribunals is what is left to the discretion of the Chief Justice. Because if you look at 142, it says there shall be established in each region of Ghana such regional tribunals. And this is not far-fetched, because in every region there are some regions where we have multiple high courts. In Greater Accra alone, we have over 20 high courts. Yeah. So it will not be far-fetched to say.
So Reindorf, you are saying attention ought to be paid to there shall be established.
Exactly.
In each region of Ghana, such regional tribunals as the Chief Justice may determine. The may that comes at the end should not give the Chief Justice the discretion to say there will not be a regional tribunal.
Exactly. It rather give the Chief Justice the discretion to determine how many regional tribunals should be in a particular region.
I follow that.
Yes, that is how I understand the provision.
Isn't that consistent with the Constitution, gentlemen?
Yes, because then to give the power,
I don't think so.
There shall be established. Is there an option in it?
There shall be established.
Means?
See, that the establishment is contingent on the thinking of the Chief Justice. That is what it means. It is not automatic.
Okay,
so
thank you.
We don't have resources.
Okay, so if
how is he going to establish it?
If you are not varying your point, let me continue with him. There shall be established. Does it give the Chief Justice any room?
Something.
Wait, hold on. Does it give the Chief Justice any room? There shall be established.
The may that comes at the tail end.
Yes.
And Twumasi Ankrah's interpretation, the quick response that any judge will give him is that if the drafters of the Constitution wanted to achieve his interpretation, his objective, they would have done the language expressly to achieve that.
There shall be established.
Yes. They would have, if, for example,
as the Chief Justice may determine, so that there's rationality about it.
Yes.
Let's read it again.
Yes.
There shall be established in each region of Ghana.
Yes.
Such regional tribunals as the Chief Justice may determine.
Yes.
So you are saying the power is with the Chief Justice and not with the beginning shall.
No. At all.
Okay. Twumasi, continue.
Samson, once again, with deference to my learned senior and law lecturer, Mr. Kwame, and my learned senior, Atasha, I concede the point they make. But if we should take that view, then essentially we are saying that Article 126 and its introduction of regional tribunals as part of the judiciary is misconceived. Because Article 126 establishes what our judicial architecture is, and clearly says that our judicial architecture includes regional tribunals. Then it goes on, if you look at 132, it goes on to now give specific provisions to deal with the structures and the composition of each of the superior courts. We have provisions for the Supreme Court, provisions for the Court of Appeal, provision for the High Court and regional tribunals. And it goes on to talk about the composition of the regional tribunal, which includes the Chief Justice and a chairman who must be qualified to be a High Court judge.
We understand
that. That is at least 10 years standing as a lawyer.
But
yes, now Samson, even away from that, if you look at Article 1252 of the Constitution, that becomes the foundational basis for why we need regional tribunals, because Article 1252 actually encourages popular citizen participation in the adjudication of justice, in the administration of justice, and actually gives 4 ways by which the public can partake in the administration of justice, which is 1, jury system, the assessor system, public and customary tribunal systems. So these are the means by which the Constitution itself allows for the citizens of Ghana to participate in the administration of justice. Surprisingly,
the citizens of Ghana are already participating in the jury, in the justice system through the jury and the assessor system. Correct?
Yes, and nobody is complaining. So why is there this attempt to cause certain disaffection about the introduction of regional tribunals, which would encourage further public participation?
We are not introducing regional tribunals at all. The
normally we say. Normally we say that you do something to cure a certain mischief. What are we solving by bringing the regional tribunals? What is missing in the high courts or the circuit and district court system that we want the regional tribunals to cure?
Samson, in fact, this one, the mischief that is, we are not seeking to cure any mischief. The rationale for having regional tribunals is contained in Article 125 itself. And I've said it is to encourage the participation of citizens in the administration of justice. And Samson, it is not far-fetched, because if you look at 1251, it says that justice emanates from the people, and it shall be exercised on their behalf by the judiciary. And then the same constitution that vested the judiciary with the power to administer justice on behalf of the citizens now goes on to say that, nonetheless, we are going to create instances where the citizens can also participate and administer justice directly. So I don't know whether we are arguing against the constitution, because it's not an act of parliament that is sought to be introduced, that is sought to be used to introduce the tribunals. It is the constitution itself that has introduced it and then gone ahead to give us a structure of how it should function. So this whole debate about
the fact that the NPP's regime abolished the district and circuit tribunals and left the regional tribunals may suggest that they don't have a problem with the regional tribunals. And if you hear Bafo's question, the question was about why are you bringing back the district and circuit tribunals, not particularly about the regional, except that there's inconsistency, because you hear the other members, including the former Deputy Attorney General, all say we don't want tribunals at all.
Look, Samson, if you look at, as I read, Article 125 allows for public and customary tribunals. And I think it is I believe that it was based on this provision that hitherto we had the district tribunals among others. But Samson, laws, I mean, once you have the numbers, you can always repeal a law if you don't find favor with it.
But if the system is broke, you don't fix.
But Samson, the system, nobody has argued that there's a broken system. This is actually the system. The system that exists is that regional tribunals are part of our system. So there's no fixing is being done. Regional tribunals, to fix it would mean to rather repeal or take out, as my learned senior Kwame Jan has said, take out the regional tribunals.
Thank you. Thank you very much.